Senator from Rhode Island.
Is the Senate presently in a quorum call?
No, we are not.
Then let me get to the point at hand. I am back now for the 27th time to call attention to the right-wing billionaires' scheme to capture and control our Supreme Court and connect it to things that are going on at the court right now. The billionaire elite that captured our Supreme Court wants to use it to attack Americans' ability, our ability as a people, through regulation to protect our own health and safety. And the goal mostly is to benefit the big polluters in their midst. A word on regulation. As modern innovations have raised the standard of living in the United States and around the world, and corporations have grown to international behemoths, and billionaires have claimed for themselves a larger and larger share of the world's wealth, regulation has come to have a very important role. Big corporations' well-known motive to maximize dangers, to maximize profits, I should say, inevitably causes dangers to society. If you think of a big industrial plant that, without oversight, would leach chemical byproducts into the soil and water, poison wells, and spread cancer, you've got an idea of why regulation is needed. Over many decades, Congress created administrative agencies to perform this task, staffed by scientists and other experts to use their expertise to manage and rein in these industrial dangers. The American system of regulation made our society safer and more prosperous, period. As heavy equipment and dangerous chemicals came to mines and factories and construction sites, regulators implemented workplace safety standards. The meatpacking jungle led to sanitation requirements in production facilities. Automobile highway carnage produced seat belts and airbags. Stock jobbing boiler rooms and insurance fraud provoked regulation to protect investors and insureds. What's been the result? Workplace illnesses, injuries, and deaths declined. Foodborne illnesses that used to kill thousands of people per year have been practically wiped out. Highways are no longer carnage. Boilers rarely explode. And medications and stock offerings and insurance policies are all safer for consumers. And by the way, in this environment of safety, corporate profits soared. The S&P 500 has returned in excess of 7,800%. Clean air and clean water and safe food and cars are actually good for business. Regulation is good. Regulation is a public good. But a gang of recalcitrant polluters is in the crew that captured the Supreme Court. And they want not only to pollute for free, they want to pollute without expert regulation. Well, even Republican Congresses wouldn't go for that. So they turned to their captured, unaccountable court. First, they got the court to create a brand new so-called major questions doctrine, basically a too big to regulate escape hatch for big polluters. And now they're using their captured court to attack another precedent, the legal doctrine known as Chevron deference, which is pretty simple. Unless the law is clear, on technical matters, courts defer to the agency experts. This arrangement makes sense. Congress isn't suited and usually hasn't the expertise to make fine technical determinations. So to prop up their attack on this common sense principle, polluters have invented some fake arguments. A few years ago, these industries and their right-wing front groups began arguing that Chevron deference has a separation of powers problem. It may make all the sense in the world, but it has a separation of powers problem that courts must attend to because, they say, it gives unchecked and disproportionate power to the executive branch. The problem with that argument is that it is just not true. It is flat out false. Congress's legislative grant of administrative authority to agencies comes with significant checks and balances. I'm not going to go into all the details, but for starters, agency heads are appointed by an elected president and confirmed by an elected Senate. And agencies may not promulgate rules willy-nilly. They have to take public notice and comment. And agency rules are subject to judicial review to make sure they're consistent with the rules and the Administrative Procedures Act and the public information and comment and the evidence. That helps make sure that regulations by law have to be both reasonable and consistent with the evidence and the facts. And in Congress, when all that is going on, we exercise direct oversight over these administrative agencies. We do it through our oversight committees that have specific jurisdiction on specific agencies. We do it through the appropriations process. Very often you see appropriations riders to control agency behavior. And we do it through the expedited review of the Congressional Review Act, which we're seeing a lot of now in the Senate. And it allows for very quick review by Congress of a challenged agency rule. And in fact, Congress has used that process to overturn agency rules 20 times since 2001. The legal vehicle for the polluters' attack on Chevron comes in a case called Loper Bright Enterprises. As usual, where polluter interests are involved, this case brought out a rogues gallery of what I would call the usual suspects. Front groups that have spent decades trying to dismantle the government's ability to regulate the big industries who secretly fund the front groups. They arrive at the captured court at the end of a long process that began with industry-funded think tanks that reverse-engineered fringe ideas and legal theories that will serve right-wing donor interests. Then those fringe ideas and legal theories cooked up in the doctrine factories get taken into other think tanks and around captured trade associations and bounced around and put more and more into the public debate. And ultimately, once they've been credentialed by this echo chamber of front groups, they get pushed, these manufactured legal theories get pushed into courtrooms around the country, very often through coordinated flotillas of secretly funded amicus briefs. There's a whole ecosystem of secretly funded corporate front groups that manage this whole process. It seems complicated, but it's less complicated than a piano, and people know how to play pianos. Now, much of this is funded by the Koch brothers. Now one is deceased, but the Koch Industries political influence operation, which is a powerful right-wing dark money political network. Look at this Loper case. The lawyers who represent the petitioners in this case are working for free, supposedly, ostensibly for a public interest law firm called Cause of Action. This supposed public interest law firm discloses no donors and does not report any employees. As the New York Times discovered in this article, those lawyers actually work for Americans for Prosperity, the central battleship of the Koch brothers' political front group armada. That armada, by the way, is very cozy with some of the far-right justices of the Supreme Court. Indeed, ProPublica has reported that Justice Clarence Thomas has repeatedly flown out to serve as the celebrity draw for the Koch political operations fundraisers, including funding that landed at Americans for Prosperity. As is now standard practice in these cases, a flotilla of dark money front groups appeared as amici curiae, purporting to be independent, but actually with enormous common funding and orchestration. These front groups are frequent flyers that spout anti-regulation arguments before the Supreme Court regularly, like, for instance, the major questions doctrine I mentioned earlier. From the creation of these doctrines in right-wing hothouses, through their amplification via right-wing front groups, to their insertion into legal arguments by right-wing amici, the common thread through the whole process is massive secret funding from billionaire special interests. The amici supporting the petitioners in the Loper case include the Buckeye Institute, the Cato Institute, the Competitive Enterprise Institute, the Landmark Legal Foundation, the Mountain States Legal Foundation, the National Right to Work Legal Defense Foundation, the New Civil Liberties Alliance, the Pacific Legal Foundation, and, of course, our friends at the United States Chamber of Commerce. All of them have received hundreds of thousands, sometimes millions of dollars from these right-wing donors, from Donors Trust, from Donors Capital Fund, from the Koch family's foundations, from the Bradley Foundation, and in some cases, from good old ExxonMobil itself. These two, Donors Trust and Donors Capital Fund, are donor-advised funds that allow ultra-wealthy interests to direct funding anonymously to their pet projects. They are essentially identity laundering operations. The money comes in from the donor who wants to be secret. It lands at Donors Trust. They, in turn, give it under their own name. The recipient gets it, and there's no record of who the true donor was. Donors Trust has been described as the dark money ATM of the right. And with Donors Capital, it has laundered over $1/3 trillion, $1/3 trillion into climate denial operations. Many of these same amici also received Koch Family Foundation funding and Bradley Foundation funding. Those are two other top 10 funders of climate denial. Fossil fuel corporations like ExxonMobil have also directly funded some of these amici. This is an operation. This is a part of a scheme. ExxonMobil has given significant money to the Cato Institute, the Competitive Enterprise Institute, the Landmark Legal Foundation, and the Mountain States Legal Foundation, as well as the Pacific Legal Foundation, and that's what we know. There could be other money that went through Donors Trust, for instance, and into these groups, and the ExxonMobil name was laundered off the funding. Now, some of these amici also receive funding from groups affiliated with Leonard Leo. Leonard Leo has been the operative for the billionaires in the court capture operation. And this is a chart of some of the front groups that Leo coordinates. This question of capturing the court in order to undermine public safety regulations, Trump White House counsel Don McGahn actually called these two operations two sides of the same coin. We have it from inside the White House that these schemes are coordinated. The Loper Amicus, Advancing American Freedom, received $1.5 million from Leonard Leo's Concord Fund, this group, between 2020 and 2021. Leo's Concord Fund operates under the fictitious name Judicial Crisis Network. And operating under that fictitious name, spent millions of dollars on court capture. For instance, on advertisements for the right-wing nominees to flood the airwaves with TV ads supporting them. And by the way, it also supports Republican state attorneys general who then challenge federal regulations the billionaires don't like before the sympathetic judges that were put on courts through this operation. Just to give you an idea, the Concord Fund and the 85 Fund are the two kind of base entities. They operate out of the same location with overlapping staff and funders and directors. I would argue that the corporate veil between the two could be pierced with a banana. And that operation of these two entities, a conjoined 501c3 and 501c4, then has these different legs. Each one of these 6 legs is a fictitious name filed under Virginia corporate law through which these entities operate. It's not a separate thing. It's just a fictitious name for, in this case, Judicial Education Project for the 85 Fund. So these 8 organizations are, in effect, the same organization. And out of it, money gets pumped up to these entities, which are Leonard Leo's means of extracting wealth for himself, for his services provided in making sure that this piece of his operation can go forward and help capture the court. So that's the background of all of this. So when Judicial Crisis Network shows up here, it's a pretty significant tell that there's more going on here than just independent organizations bringing their views to the Supreme Court. And it's not enough to flood the Supreme Court with this fake onslaught of coordinated amici curiae. There's also been a coordinated editorial campaign. In fact, it's been hard to miss the editorial campaign launched to create favorable ideological terrain for the captured court's justices to end Chevron deference. The right-wing apparatus has cranked out op-eds in just about every major publication across the country in the past week. It has been a surge of propaganda, pushing that falsehood about unaccountable bureaucrats. One particularly odious editorial appeared in the pro-Polluter Wall Street Journal editorial page. I refer to it just generally as the Polluter page because that's its reason for being. And it was written in the Wall Street Journal editorial page by Mr. David Rivkin. Mr. Rivkin is described as follows by the Wall Street Journal. Mr. Rivkin served at the Justice Department and the White House counsel's office in the Reagan and George H.W. Bush administrations, period. Oh, but he has done so much more. For instance, he is Leonard Leo's personal lawyer. This guy, with what my office refers to as the Leo bug of phony front groups, has this guy, who authored the Wall Street Journal editorial, as his personal lawyer. And by the way, Rivkin is the same guy who several months back gave Justice Alito a very friendly interview right in this Wall Street Journal editorial page to justify Alito's undisclosed travel on a private jet on a freebie trip accompanied by, Leonard Leo, no less. And he's the same guy who, in a current case before the Supreme Court, before Alito, who has not recused himself, is attempting to secure an enormous tax giveaway for billionaires. Rivkin's co-signer, Mr. Grossman, Andrew Grossman, is described as a senior legal fellow at the Buckeye Institute and an adjunct scholar at the Cato Institute. Okay, that's a pretty fair description. And by the way, if you go back here, there's the Buckeye Institute, there's the Cato Institute. They've already briefed the case. The lawyer who writes the briefs is now just pumping his own amicus brief in the Wall Street Journal editorial page with the lawyer for Leonard Leo, who did Justice Alito the big favor of trying to head off a Senate investigation into Alito's travels. So it's a pretty rich mix. And if you look at all of this, what you discover is that this whole scheme is actually pulled off by a very small number of people on the billionaire's payroll. They're very busy constantly switching hats and running multiple front groups out of the same enterprise. So it looks like there's more. Filing multiple briefs in a Supreme Court case. So it looks like there's more, but it's actually a pretty small billionaire-funded operation. It's just been diabolically effective, and it's begun to pay off for the billionaires. In West Virginia versus EPA, the Supreme Court hobbled agency authority to regulate for our public health and safety by adopting what they called the major questions doctrine, same one I mentioned earlier. And that, in turn, has prompted an onslaught of challenges to administrative regulatory authority from which the administrative law legal landscape is still reeling. There is enormous upheaval from that novel doctrine imported by the billionaire-selected justices of the Supreme Court into American law. It would actually add insult to that injury for the court to break even more precedent by attacking Chevron. And frankly, they may not really even need to, because the major questions doctrine is such a powerful weapon in their hands against administrative safety regulation that they may not actually need to do much damage to Chevron. They've got a weapon. But it looks from the argument like the court is actually poised to attack Chevron deference. If it does, it not only will add to the dangers to Americans' health and safety against which regulation protects, but it will also move the unaccountable Supreme Court further into the policy-making function properly left under the American system of government to the elected political branches. In short, it's a power grab by the unelected judicial branch at the behest of and for the benefit of polluter billionaires. And they have done this on the specious grounds, the false grounds that these administrative agencies are unaccountable. Well, even if that claim were true, it's hardly solved by moving the locus of decision to the least accountable part of the government, to the United States Supreme Court. If your problem is that decisions are being made in unaccountable fashion by bureaucrats, then moving it to even less accountable judges is not a solution to the problem. But the fact of the matter is that they're wrong about the bureaucrats, because of the CRA, because of the Administrative Procedures Act, because of appropriations process, because of congressional oversight, and because of executive appointment to the control of these agencies. It just ain't so. But it's a lie that is repeated and repeated and repeated and begins to be echoed by the justices of the captured court. To sum up, by all appearances, a Koch operation-funded legal theory supported by Koch operation-funded Amici is about to be deployed by Koch operation-funded lawyers to convince Koch operation-funded justices to achieve a long-standing goal of Koch Industries, the ability to pollute more easily and more cheaply. To twist American law through those techniques for that purpose is a deeply degraded thing. It would be a tragedy for the American people, but you know what? It's the scheme in a nutshell. It's why all the effort was put together, the hundreds of millions of dollars were spent to capture and control the United States Supreme Court for the benefit of a small cabal of creepy billionaires. To be continued. I yield the floor. Quorum.
Clerk will call the roll.
Ms. Baldwin.
Madam President.
Senator from Rhode Island.
Madam President, let me start by thanking our Finance Committee Chairman, Chairman Wyden, for his strong leadership. Chairman Wyden was able to secure the cooperation of the wealthy donor who gave Justice Thomas the $250,000 plus RV loan. The chairman doggedly followed the facts to get the truth for the American people, which takes guts, particularly when you consider the many special interests rooting for this investigation to go away. And while I'm thanking Chairman, let me also thank Chairman Durbin for his persistent and dogged pursuit of the truth through the Judiciary Committee. Both the Judiciary and the Finance Committees are working to get to the bottom of this. Keep in mind, in all the ethics mess engulfing Justice Thomas, that for every ethics issue, there is also likely a tax issue, perhaps two sides of the same coin. If a justice isn't reporting income on his legally required financial disclosure, there's a good chance that something is amiss with his tax reporting as well. When a justice receives something of value from a benefactor, the presumption is that it needs to be disclosed under the ethics law either as income or as a gift. Generally speaking, if it's income, the justice must also report it as income for income tax purposes. And if it's a gift, the donor needs to report it for gift tax purposes, which is why, when you are looking at possible ethics violations in situations like this, it is important to know if that income showed up on the tax side, or if that gift report showed up on the tax side. That's why Chairman Wyden's leadership here is so essential. If this went unreported, that could be a tax law violation. Again, if it's a gift, the justice needs to disclose it under the ethics law, unless it falls under a narrow definition for personal hospitality, spending Christmas with your in-laws, for instance, or going on a trip with your college roommates. So either way, the tax question becomes, for donors, for gifts, did the benefactor, did the donor report it for gift tax purposes? So you've got the income tax reporting issue, you've got the gift tax reporting issue, and you've got a third issue, which is that these tax filings can also test the veracity of what justices claim. Justices Thomas and Alito claim they didn't have to report free jet and yacht travel gifted by billionaires because those gifts, they claimed, were personal hospitality. There were no college roommates or in-laws involved. It's a heck of a stretch to call this personal hospitality, but one of the ways you could test whether it's personal hospitality would be by looking at how the donor of that hospitality treated it on their taxes. It would be a pretty good tell that all that hospitality those justices received was not so personal if the yacht and jet travel gifted to Justices Thomas and Alito was written off by these billionaires as a tax expense, as a business expense. So there's a lot to be learned from tax filings. Two other reminders as we go through this. One, it's a crime. It's a crime under 18 United States Code Section 1001 to file a false sworn statement with the federal government. Both judicial disclosures and tax filings are filed under oath. Two, the law requires the judicial conference, if there's any question about whether an improper judicial disclosure filing might have been willful, to refer the question of willfulness to the Attorney General for investigation. It is not under the law the judicial conference's job to decide the question of willfulness. It's only to decide if there is a question of willfulness and then refer that to the Attorney General for investigation. So this can get serious fast. Which brings us to Justice Thomas and his RV. When it comes to ethics requirements, there is no question about what the law required here. If part of Justice Thomas's debt was forgiven, he had to report it. The state of the facts, based on the documents the Finance Committee has obtained and reviewed, is that Justice Thomas never paid back a dollar of principal on a $250,000 loan, and that the donor long ago stopped collecting even interest on that loan. So let's take a look at the law. Justice Thomas likely didn't have to report the loan itself. Justices don't need to report loans secured by a personal vehicle as long as the value of the loan isn't worth more than the vehicle itself. If Justice Thomas put up the RV as collateral for his loan and did not obtain more money than the RV was worth, there was no need for him to disclose the loan. But all that changes if any part of the loan was forgiven later on. And as the chairman has said, when you've collected not $1 in principal and stopped collecting interest, that sure looks like forgiveness of a loan. And a loan you don't pay back is a form of income. The law requires officials to disclose any income they receive outside of their government salaries, which makes sense if you're trying to expose or prevent corruption. Under the law, if you receive more than $200 in income from any one person in a year, you have to disclose that. Here are the regulations on financial disclosure. These are regs adopted pursuant to law, and they say that income includes but is not limited to income from discharge of indebtedness. And down here it further says that you must report discharge of indebtedness. And if you go to the tax code, specifically to 26 U.S. Code section 61, which defines income for tax purposes, subsection A, subsection 11 of subsection A describes that income from discharge of indebtedness counts as income. Income from discharge of indebtedness. It's the identical language in the tax code and in the judicial reporting regulations. So a loan whose principal is not repaid is reportable income, both under judicial ethics law and under tax law. And the law is crystal clear on this point, and even justices are told what the law is on this point. So if you go to the filing instructions for judicial officers, this is what a judge gets that tells them how to comply with their filing requirements regarding these disclosures. Here's what it tells them. Income. The disclosure of the gross amount and the type of income, dividends, rent, interest, or income from discharge of indebtedness is required. Disclosure of income from discharge of indebtedness is required. There is nothing very subtle or complicated about that. Couldn't be more straightforward. If Justice Thomas failed to report a loan that was no longer being collected with a big balance still due and hence was, as a practical matter, forgiven, he likely violated these requirements. If he failed to file his taxes accordingly, he also likely violated our tax laws. And either of these, either the tax filing or the filing under the judicial disclosure rules, could amount to a false statement under the criminal code. In the first instance, as to the judicial disclosure filings, the law requires the judicial conference to determine if there is reason to believe that Justice Thomas's violation may have been willful, in which case it has a legal obligation to report him to the Attorney General for further investigation to settle the question of willfulness. I've asked the judicial conference to consider exactly these facts, and I hope that they will do so. It looks like they are. And as they do so, here are some things they should consider. First, this is not Justice Thomas's first brush with this law. A previous episode of yacht and jet travel gifts to him from Harlan Crow actually went to the judicial conference for investigation years ago. In my subcommittee on the Judiciary Committee, we held a hearing about this with a judge who served on the judicial conference at the time and could relate to us what transpired back then with the Crow to Thomas yacht and jet travel undisclosed gifts. That episode I would describe as a decent burial. But it's not clear now that with Thomas back as a repeat offender with the same type of gifts from the same billionaire, that he will get the same courtesies from his fellow judges as he did in episode 1 of Crow to Thomas yacht and jet travel gifts. Indeed, the latest report from the Judicial Conference, they put out 2 reports a year, and this is their report of proceedings for the previous fall, for this past fall, i.e. this is their most recent report of proceedings, dated September 12th of last year, and it has this rather Delphic sentence in it. The committee was also updated on the status of the ongoing review of public written allegations of errors or omissions in a filer's financial disclosure reports that were referred to it since the conference's last session. I don't know of any other judge or justice who has received public written allegations of errors or omissions in that filer's financial disclosure reports other than Justice Thomas. So although there's no name mentioned here, it looks very much like the Thomas investigation is alive and well in the Judicial Conference. And if they should determine that there's a question of willfulness in his failure to file, particularly to the extent that it may involve similar failures in tax filings, it is their legal obligation to present that question to the Attorney General. So it appears that the matter remains under active review, and I would conclude by saying this is to be continued. I yield the floor. Thank you, Mr. President. I am back now for the 28th time in my series of speeches on the special interest scheme to capture the United States Supreme Court. What I'd like to do today is to talk a little bit about the Judicial Conference and what the Judicial Conference has been doing to help clean up the mess at the Supreme Court. I suppose I should start with what is the Judicial Conference? The Judicial Conference is a body created by Congress around 100 years ago as the chief governing and policy-making body of the federal judiciary. It basically supervises the administrative side, not the adjudicative side, the administrative side of the judicial branch of government. It is chaired by the Chief Justice, and its membership is composed of the chief judges of each circuit and of the Court of International Trade. So it's a very distinguished group of very senior appellate judges and a district judge from each circuit, typically a chief judge or a senior judge. Again, it's a pretty distinguished group. The conference is responsible for, among other things, enforcing ethics rules and overseeing financial disclosures and setting other policies across the federal judiciary, which it mostly does through committees. It has committees on issues ranging from financial disclosure to things like courtroom security. The Judicial Conference has a very important role enforcing judicial ethics rules. Ethics rules are within its ambit of responsibility. Now, bearing in mind the recent ProPublica story concluding that the Judicial Conference has, to quote the story, often protected, not policed, the judiciary, I wanted to share my experience as I've conducted this investigation and how we've been able to work with the Judicial Conference. First, let me say as a general matter that the Judicial Conference is very reticent. Getting even basic information like which judge serves on which committee is an uphill struggle. Last year, Business Insider, the publication, sought the list of members of the Committee on Financial Disclosure, and the conference initially denied the request. I'm not going to tell you, saying that the names of the members of the committee are not public, which is kind of a strange position to take when they're paid by taxpayers to do that work, and all you're asking is who they are. But thankfully, later, the conference reversed course. I have requested that the Judicial Conference disclose information like who sits on its committees and what rules they operate by, but so far I have not yet received a formal response to that, and I very much hope that the members of the Judicial Conference will make this information public. Transparency is not a bad thing in this area. Anyway, through all of its established reticence, when I have brought issues to the attention of the Judicial Conference through correspondence or through remarks that I deliver at the conference's twice-annual meetings in Washington, which I'm invited to in my capacity as the chairman of the Senate Judiciary Courts Subcommittee, the conference has generally produced positive results. My requests have covered 4 areas, and I'll give you a quick overview of where those matters stand. First, I'll talk about the disclosure rules for Amicus Curiae briefs, friend of the court briefs. Dark money front groups send flotillas of amicus briefs to the Supreme Court. The justices and their clerks read these briefs. They often cite them in their official decisions, but it's basically judicial lobbying. And the problem is that this flotilla of amicus briefs doesn't have to disclose the true source of the funding behind the briefs. So neither the justices, nor the other parties, nor the public gets to know who's really paying for these arguments to be presented to the Supreme Court. Nor do we know the interconnections among the front groups. To what extent are they a single web of front groups masquerading as a great number of individual entities? We know for sure one thing: there was a brief filed under the fictitious name of another organization. It wasn't even a real entity that filed the brief. It was the, quote, fictitious name under Virginia law of a completely different group. And that was done without disclosing the name of the actual group to the court. That means it's left to offices like mine to track these groups and then explain to the court, which we do in our amicus briefs, how all of this flotilla of briefs is coordinated. Very often, we see common dark money donors. Very often, we see the fingerprints of the right-wing billionaire's court fixer, Leonard Leo. Time and again, dark money groups pay huge sums to support right-wing justices' confirmation onto the court, and then turn around and file amicus curiae briefs to signal to those justices who they help get on the court how they should roll. So since 2019, I've asked the Supreme Court to strengthen its amicus disclosure rule. After much badgering, the court, to its credit, sent this matter to the Judicial Conference for consideration, where at the Judicial Conference it was in turn referred to an advisory committee. Although that advisory committee hasn't yet formally proposed a rule change, things look promising. These judges who make up the Judicial Conference well recognize the importance of, as one judge said, knowing what she called the real power behind the throne in these flotillas of amicus briefs. It is also encouraging to hear judges on the committee recognize that there is a broad agreement, which they said, on the need for better disclosure. As always, the devil will be in the details, but thus far, the Judicial Conference is on the case. It has announced that it is examining the matter. Another issue that I have raised with the Judicial Conference is what I call the Scalia trick: misuse of the personal hospitality exception in the financial disclosure rules. Justice Scalia got this trick named for him by taking dozens of high-end hunting trips for free, and he used this rule to avoid disclosing them. He pretended that a personal invitation from a resort owner whom he had perhaps never met made it, quote, personal hospitality protected by the rule. Senator Graham and I first sent a bipartisan letter to the Supreme Court about abuse of the personal hospitality exception back in 2021, and I'd ask unanimous consent to have that letter appended at the end of my remarks. After that, I sent several more letters asking the court to address the Scalia trick, and I'd ask those 3 letters to also be appended at the end of my remarks.
Without objection.
The good news is that in March of last year, the Administrative Office of the Courts wrote me to say that the Committee on Financial Disclosure would clarify its regulations on personal hospitality. I'll quote that word again, clarify, because it matters later. And sure enough, when the clarification came out, the Judicial Conference slammed the door hard on the Scalia trick. So no more secret flights to and from hunting trips across the country on someone else's dime. No more secret personal hospitality paid for by a third party. And no more secret personal hospitality, so-called, at properties owned by a corporation. I count these clarifications as a win. So I'll put that into the win column. There is a related question still pending from that. Justices Thomas and Alito claimed last year this same exception, the personal hospitality exception, let them accept their secret gifts of jet and yacht travel from right-wing billionaires without reporting it. In his most recent financial disclosure report, Justice Thomas claimed that he could keep those past gifts secret because what he called the committee's new rules, his description, didn't go into effect until March 2023. And there I disagree. The disclosure law was always clear. It was the Judicial Conference's guidance that hadn't headed off the Scalia trick, likely because nobody imagined that any judge would be so bold as to have intermediaries ask resort owners to send them invitations for free travel and then call that personal hospitality. Anyway, the judiciary's letter to me said that the change was a clarification. And that word choice matters a lot here, because if it was in fact a clarification, then Justice Thomas and all the rest of the Supreme Court must amend their past filings to comport with the law, because it had always been that way. And they'd have to disclose all the freebies kept secret in previous years. So pending at the Judicial Conference is my request that the conference clarify whether the revised guidance constituted a clarification or a rule change. I do not have a response to that yet, but the end of the Scalia trick was a considerable win. I've also contacted the conference about how omissions in Justice Thomas's financial disclosure report were handled by the conference back in 2011. And I would ask unanimous consent that that correspondence be also appended at the conclusion of these remarks.
Without objection.
Thank you. Back then, Justice Thomas failed to disclose $700,000 that the far-right Heritage Foundation had paid his wife over several years. Justice Thomas's undisclosed jet and yacht travel, paid for by the right-wing billionaire Harlan Crow, also became public for the first time. So members of Congress and a watchdog group sent the 2011 omissions to the Judicial Conference's Committee on Financial Disclosure for review. Under the law, the conference is required to refer the matter to the Attorney General for further investigation if there is reasonable cause to believe that the violations may have been willful. Last year, my court subcommittee heard testimony from a judge who was then on the Judicial Conference who raised serious concerns about the conference's reasonable cause inquiry. There was actually no indication that a reasonable cause inquiry was made. So in August, I wrote to the administrative office to find out more about what really happened. The administrative office acknowledged my request, but I have not yet received a response to my questions. The Judicial Conference is also considering Justice Thomas's more recent financial disclosure omissions. Congressman Hank Johnson, who is my coordinate as the top Democrat on the court subcommittee on the House side, and I wrote to the Judicial Conference several times, along with other members of Congress, asking for review of these ethics violations and a determination whether referral to the Attorney General is required for this second round of yacht and jet travel from Republican billionaire Harlan Crow, for the real estate sale from Thomas to Crow, and for various gifts from other ultra-wealthy individuals, including Paul Novelli and David Sokol. And I would ask unanimous consent that those letters be appended at the conclusion of these remarks. There are 3 of them.
Without objection.
As in 2011, the current matter has been sent to the Committee on Financial Disclosure. We don't know exactly how the committee's review is going, but the Judicial Conference's report on its September meeting, its most recent meeting, included this interesting note on the committee's activities. The note said the committee was, and I'll quote here, updated on the status of the ongoing review of public written allegations of errors or omissions in a filer's financial disclosure reports that were referred to it since the conference's last session. So it seems like that is this matter, and it seems like that investigation is an ongoing review. The final issue I've raised with the Judicial Conference is my complaint against Justice Alito for what I thought was a pretty blatant ethics violation last summer. I addressed this complaint to Chief Justice Roberts in his capacity both as Chief Justice and as Chair of the Judicial Conference. And I'd ask unanimous consent to have that letter appended also at the conclusion of these remarks.
Without objection.
The Supreme Court, unlike every other federal court, has no procedure for receiving or investigating ethics complaints. So that's why I sent it to him wearing both of those hats. The first thing I asked Chief Justice to do was to change that. There should be a place where with a complaint like that, I could go and file it and somebody would pay attention. I also asked that either the conference or the court conduct its own investigation into Justice Alito's comments in the Wall Street Journal's editorial page made in an interview with David Rivkin, where Justice Alito offered his legal opinion that, and I'm quoting him here, no provision in the Constitution gives Congress the authority to regulate the Supreme Court, period. Well, it seems to me that's a slam dunk ethics violation for a couple of reasons. First, Justice Alito was opining on the constitutionality of my Supreme Court ethics bill, which the Senate Judiciary Committee had recently advanced, and the legitimacy of related oversight requests from the Senate Judiciary and Finance Committees. We have heard time and time again from Supreme Court nominees, including Justice Alito himself, that it is improper and a disservice to the judicial process, those are Justice Alito's words in his nomination hearing, for them to express opinions on a matter that might come before the court. Well, boom, this was a matter that might come before the court. Indeed, it was actually likely to come before the court. And there he was opining at will in the pages of the Wall Street Journal editorial page. But it gets worse. He made his comments in the context of a specific ongoing legal dispute, a dispute involving the court fixer, Leonard Leo, who had arranged for an undisclosed free jet trip and fishing excursion for Justice Alito and himself. When the Senate Judiciary Committee requested information about the gifts Leo arranged, we got a letter back from his lawyer, David Rivkin, the same person who conducted the interview that recruited the comment from Justice Alito. Justice Alito's comments in the Wall Street Journal echoed the exact argument that Rivkin had made when he refused to give us any information, i.e. that Congress has no authority to legislate on or oversee Supreme Court ethics, which is a weird position to take when you consider that the Judicial Conference, which oversees Supreme Court ethics, was created by act of Congress. Anyway, the cherry on top of this whole mess, which I flagged also for Chief Justice Roberts in a follow-up letter, which I'd ask unanimous consent to append at the conclusion of these remarks,
Without objection.
came a month later when another billionaire, also alleged to have provided Justice Thomas with undisclosed gifts, cited Justice Alito's comments as support for his argument that his billionaire didn't have to answer our questions about those gifts. I sent that letter to Chief Justice Roberts as an addendum to my complaint, and I have not yet heard back. But it really does seem wrong that a justice of the Supreme Court would offer an opinion on a matter that might come before the court that actually relates to a specific ongoing legal dispute in which the lawyer for a party in that ongoing legal dispute is doing the interviewing, and that the person that lawyer represents is a friend and associate of the justice himself, and that the result of that activity is that gifts to that very justice are kept from public view, orchestrated by the client. It's a mess. The last thing that we have is a letter that Senator Wyden and I just sent to the acting director of the Judicial Conference related to the recreational vehicle loan that Justice Thomas received. It appears from the Finance Committee's investigation that the principal on the loan was never repaid, not a dollar of it, that for a period interest on the loan was repaid, but then interest stopped being repaid. When you stop paying both principal and interest, that amounts to an act of forgiveness of the loan, and yet the forgiveness of that loan was never declared on his judicial ethics filings, suggesting that it might not have been disclosed even in his tax filings, which could lead to a whole second set of legal concerns. So I ask unanimous consent that the letter and the attached report be also appended at the conclusion of my remarks.
Without objection.
So it's not fair to expect the Judicial Conference to have done anything about that because it just was sent to them. But with respect to the other things, I'd sum it up this way. The score at the Judicial Conference so far is one clear win on getting rid of the Scalia trick, major progress on disclosing who's really behind front group Amicus, ongoing review of the billionaire gifts program at the court as it relates to Justice Thomas in particular, and so far no response on the Alito Wall Street Journal mischief. So it's, like I said, it's a very reticent place, and they move very slowly and with a lot of process, so I'm just going to continue to press along, bringing information before the Judicial Conference so that they and the public can get clear answers on these issues. Certainly the American people deserve transparency when it comes to fairness and gifts from interested billionaires to justices of the Supreme Court. And with that, to be continued, I yield the floor. Ninth time in my scheme series, explaining to the American people how the right wing managed to capture the Supreme Court. Today, I'd like to discuss the scheme's deliverables, how the court rewarded its big donors with favorable outcomes that benefited partisan, Republican, or corporate interests, and particularly today, how the Roberts Court used false facts to produce decisions like Shelby County and Citizens United. This speech is the short form. For the full analysis, for the long form, you can read my recently published law review article in the Ohio State Law Journal. False fact-finding is the trick that has enabled the court to do a lot of damage in recent years. Let's start with some basic principles about how fact-finding is supposed to work in the American judicial system. Facts are an important part of every case, and it matters to get them right. And it also matters that courts stay within their constitutional boundaries. To achieve those two purposes, the American system has facts ascertained at the trial court level. The trial court level. First, the trial judge is closest to the facts on the ground. That's where the evidence comes in. That's where each party can challenge each other's facts, where facts receive robust adversarial scrutiny. That's where the judge can evaluate credibility and dedicate the time to compiling a robust factual record. In all of this, one key point is that the judge relies on the parties to bring the facts to the court. With only limited exceptions, a court isn't supposed to venture off looking for its own facts. Once the trial court makes its decision and assembles its record of the facts, that record travels with the case when a party appeals to a higher court. As to facts, an appellate court is not supposed to find its own. It is supposed to give the lower court a lot of deference. A lower court's fact-finding can usually be overturned only if there was what's called clear error, a very hard standard to meet, as any lawyer will tell you. And even after a clear error finding, the ordinary rule is that the case is remanded back to the trial court for whatever further fact-finding is required to comply with the appellate court's edict. These rules make our system honest and efficient. They allow robust challenge to the facts at trial, but deference to the judge's findings on appeal. They do not set appellate courts up as fact-finders. Appellate courts focus on questions of law using the record established by the trial court. These fact-finding rules also protect our American separation of powers. Under the Constitution, courts are limited to deciding only what the Constitution calls cases or controversies. And by obvious implication, that means actual cases or controversies with their actual facts. Without that, judges could make decisions based on hypothetical facts, in effect, offer unconstitutional advisory opinions. A court can't honor the Constitution's case or controversy requirement without cabining its decision to the actual facts of the case or controversy and to this established fact-finding process. If that limitation did not exist, appellate judges could become, as one famous judge warned, a knight errant, roaming at will in pursuit of his own ideal of beauty or of goodness. One other fact-finding body needs mention, and that's Congress. Congress is the Constitution's policy-making body. That's our job. Not because we are geniuses, but because if our ideals of beauty or of goodness don't match the public's, the public can throw us out. That's democracy. The democratic process provides the public protection. And Congress has its own fact-finding authority under the Constitution. We often find facts ourselves, creating a legislative record not the trial record of a trial court, a legislative record of the proceedings leading to a bill. This fact-finding authority merits deference from courts. Again, not because we're smarter, but because we are correctable through democratic process. Which brings us to the mischief at the Roberts Court. For more than a decade now, the Roberts Court has violated these basic principles, replacing facts found by Congress and facts found by lower courts with fake facts that they made up on their own. Fake facts that over and over just happen to suit the big donors who put so many Republican-appointed justices on the Supreme Court. Shelby County and Citizens United, both those decisions, stood upon falsehoods presented as facts. And these weren't just drive-by errors in passing of no moment. These were false, factual findings that were essential to prop up the logic of the court's holdings. No false facts, no desired outcome. And tellingly, even after events thoroughly disproved the false facts, the Republican Supreme Court refused to correct its mistakes. And so these faulty decisions, founded on false facts, live on like zombies plaguing our democracy. Let me talk about those two cases, because they're probably the worst examples. In Shelby County, the Supreme Court said that the most important part of the Voting Rights Act, the part that required states with a history of racist voter suppression to get clearance before new voting laws went into effect, was no longer justified. That part of the law was just no longer justified because, quote, things had changed. According to Chief Justice Roberts, conditions in those states had improved so much that Congress should no longer screen their laws for racist voter suppression. That false fact was key to the analysis overturning this part of the Voting Rights Act. But there was no record support for that false fact. It just popped out of the heads of the justices who wrote that decision. In actuality, in Shelby County, Congress had compiled thousands of pages of evidence, a record of facts, collected through extensive hearing and research regarding the danger of minority voter suppression in those so-called pre-clearance states. The court ignored that. Worse still, pre-clearance states, no longer subject to these Voting Rights Act protections, immediately proved that the dangers that the court said weren't there were in fact there, that these dangers were true, moving immediately to enact laws that targeted minority voters with almost surgical precision, as one court put it. Despite the evidence before and after disproving the court's so-called finding in Shelby County that everything was okay now, the Roberts Court has refused to budge, leaving that zombie decision in place. The trick was even clearer in Citizens United. The bipartisan campaign finance law at issue was supported, again, by a robust congressional factual record. Congress had held hearings, gathered firsthand accounts, and wrote lengthy reports on the problems plaguing our campaign finance system. Lower courts had also assembled similar records with evidence of these problems, many of which suggested corruption. All of that was ignored. the Republican-appointed justices in Citizens United had a problem. Congress gets to legislate to protect the integrity of elections. We get to legislate to protect elections from either corruption or the appearance of corruption. So, to get around that, to keep Congress out of protecting the integrity of our elections, the justices had to come up with a way of arguing that unlimited political spending in politics wouldn't, and indeed couldn't, harm election integrity. They had to manufacture that finding to subvert Congress's power. And to get there, they had to make two factual findings. First, they argued that there was no risk of corruption or even the appearance of corruption because all this new spending they were going to unleash would be independent from the campaigns the spending was supporting. Well, that has been proven abundantly false. Even more obviously, they said that all this new political spending they were unleashing would be transparent, not just independent, but also transparent. That voters would know who was behind the big, unlimited political spending and could make their decisions accordingly. And therefore, the danger of corruption was lifted by the fact that the voters would know whose money was behind the ads. Well, folks, it is non-debatable that that fact is false. Partisan billionaires and corporate special interests have spent billions in dark money. This is so widely reported and incontestable that an honest court could probably even take judicial notice of the billions in non-transparent and therefore corrupting political spending. A lot of this money is supposedly independent, but in reality, the groups that spend it use all sorts of well-documented loopholes to coordinate with candidates and campaigns right in broad daylight. The tsunami of dark money that Citizens United unleashed has, as predicted, corrupted our democracy. The court didn't have to wait for the newspaper to know that the facts it found were false. Shortly after Citizens United, a state campaign finance case came to the Supreme Court from Montana. The Montana Supreme Court upheld a 100-year-old state campaign finance law on the basis of an extensive factual record about the history of campaign corruption specific to Montana, and John McCain and I submitted a bipartisan brief to the Supreme Court in that case. Our brief pointed out the factual falsity of the Citizens United decision, that the spending was not independent, that the spending was not transparent, and therefore those factual predicates of Citizens United failed and the decision should fall. Not only did the Republican-appointed justices summarily reverse the Montana Supreme Court, not even allowing oral argument, where perhaps this false fact-finding might have been pointed out, the court did so on the grounds that the Montana decision was inconsistent with Citizens United. No mention of the problem that Citizens United was inconsistent with the truth. Talk about a zombie decision. Since then, the court has stubbornly refused to re-examine its false facts despite several billion instances of disproof of the transparency of the funding. Worse, a couple of terms ago, these Federal Society justices started paving the way even for a constitutional right to spend dark money. The billionaire right-wing donors who packed the court did very well by these two decisions, by Shelby County and Citizens United. The suppression of minority voters across the South post-Shelby County likely flipped some elections to the Republican Party. The flood of dark money by billionaires and corporate interests was for years essentially entirely dedicated to funding Republicans in elections. If you want a specific example of corruption, look at how fossil fuel industry dark money has, since Citizens United, stopped Congress from passing any serious bipartisan climate legislation. I was here 2007, 2008, 2009 when climate legislation was very current in the Senate and very bipartisan. 3 or 4 major bills being worked on, strong bills that would have helped solve the climate problem. Then came January of 2010, that date of infamy when Citizens United was decided. Since then, that's it. No serious bipartisan climate bill. These cases happened because the court disregarded rules about proper fact-finding, ignored mountains of evidence that Congress and that lower courts had assembled, and made up facts, just made up their own facts that helped them strike down the laws, delivering those big wins for Republican donor political interests. This free-range fact-finding problem at the court is going to get worse after the court's recent move in cases like Dobbs and Bruen to base constitutional decisions under their new theory of history and tradition. This new theory opens whole new fields to judicial fact-finding knight-errantry, cherry-picking historical facts to get the outcomes that they want to reach. Dobbs, the case that overruled Roe versus Wade, stood on dubious historical sources like a 1600s treatise by someone who sentenced accused witches to death and defended marital rape to subject women's reproductive autonomy to the whims of state legislatures. Bruen, the guns case, stood on an NRA-funded version of history that one historian called an ideological fantasy to put the proliferation of guns on our streets behind constitutional protection. When the Supreme Court goes on these last-minute, no argument, made it up in our chambers, no chance of correction, fact-finding expeditions, there's no one to tell them, hey, you got some stuff wrong. There's no one else that the parties can appeal to. The factual errors slipped in at the end are protected from correction. And then the zombie cases march on. I wrote my law review article because this fact-finding trickery hasn't gotten the attention it deserves, either here in Congress or by professors and judges. There is no shortage of mess to clean up at the Supreme Court, whether it's the court's ethics crisis or the phony front group amici curiae who often show up to offer those false facts to the court without any transparency or vetting themselves. My Supreme Court Ethics, Recusal, and Transparency Act would clean up a lot of the mess. But even if we passed that law and it helped clean up the ethics mess, and even if we managed to unpack the court that dark money built, these zombie decisions, standing on false facts, would remain effectual unless we have a legal theory to address them. And my article proposes one way to scrub away these tainted decisions by returning to the historic, basic, well-established, fact-finding principles of the American system of justice. Why should we in Congress not confront the false facts of this stubbornly wrong court? And why should lower court judges be expected to blindly adopt false facts that never went through proper fact-finding procedures? Why should Congress honor decisions that are on their face founded on false facts? Remember Marbury versus Madison, that the Supreme Court famously gets to say what the law is. But it's not the last word on what the facts are. Nothing in the Constitution says we in Congress have to pretend that we really live in the alternative bizarro world of the Supreme Court's false facts. Congress need not be an idiot and accept rulings that we plainly see could not stand without indisputably false facts propping them up. The fact that the Supreme Court won't go back and clean up its false facts mess should not disable us from addressing the zombie decisions. If this requires circumscribing the court's authority, as far as I'm concerned, too bad. Better that than to have citizens have to obey flawed decisions founded on false facts just because the court liked who the winners were. This should not even be an issue. These fact-finding rules have stood for centuries. It is only this politically driven court that has stepped outside the bounds of history and tradition to go on these false fact-finding gallivants that have no proper role in judicial fact-finding and that violate the boundaries of separation of powers. Reining it back in that circumstance is a proper response. And if the court doesn't like this, I would say heal thyself. Quit breaking the historic process of fact-finding and quit finding obviously false facts and go back and clean up those false fact decisions. That's one option. They could do it. But of course, the Federalist Society justices won't, because this is a captured court, and the false fact outcomes are the outcomes the billionaires who packed the court want. To be continued. I yield the floor. For the first time in American history, a gentleman of Muslim faith has been nominated to serve on a federal circuit court of appeals. What could and should have been a moment of pride has been stained by the nominee, Adil Mangi, having been subjected to a series, a campaign of baseless and gross attacks. Senator Booker of New Jersey came to the floor yesterday and gave an eloquent and thorough rebuttal of those attacks, so I won't rehash that, but it is important that my colleagues understand where these attacks came from. It's not just they were untrue, it's that the whole campaign is a fake. These attacks are part of a coordinated campaign by the same dark money interests that helped Donald Trump pack our federal courts and who now want to stop President Biden from confirming qualified nominees who weren't handpicked by those billionaire special interests. You don't have to search long to see their fingerprints all over this smear campaign. And we can start with the main culprit the Judicial Crisis Network. Let me give you just an overview of what the Judicial Crisis Network is. The billionaire operation to pack the courts had an operative who was the staff person, essentially, who directed it. His name was Leonard Leo. Leonard Leo runs a whole array of front groups to obscure what's really going on, sort of like a pea and shell game, only with lots of shells. And this is a diagram that I use about one component of his front group armada. And what this reflects is his own companies up here, CRC Advisors, CRC Strategies, and CRC Public Relations. They're the entities through which he extracts money for services, so-called, from this array of corporate entities. And to understand what it is, the real ones here are called 85 Fund and Concord Fund. Those are twinned entities. They share office space and funders and staff. And they have around them this array of other entities, none of which are real, all of which are registered fictitious names under Virginia law, under which the real entities are allowed to operate. And in this case, there are 6 of them. And one of them is this Judicial Crisis Network. This thing is being run through a fake entity that bears the fictitious name of a completely different organization. And behind that are more anonymous funders and screeners of funding, and ultimately behind all of that, a bunch of creepy billionaires. The story of the Judicial Crisis Network is that it was the main group that the operative, Leonard Leo, used to help the billionaires pack the Supreme Court with their hand-picked justices. It spent, for instance, almost $40 million opposing Merrick Garland's nomination to the Supreme Court, and thereafter supporting the Trump justices' confirmations. It took in millions in dark money dollars, in individual contributions as big as $15 million and $17 million. This is not a grassroots organization. This is billionaire-funded, multi-million-dollar contribution outfit. And it continues to work today in the service of packing the courts. It is an organization for the billionaires to work through from behind the scenes through their operative, Leonard Leo. It launched, against Mr. Mangi, a $50,000 ad campaign called Stop Anti-Semite Adil, in which a video plays saying the Senate should reject anti-Semite Adil Mangi, and, just to make the point even more grotesque, showing a plane flying into the World Trade Center. Classy stuff. It has tweeted and promoted the false attacks that Senator Booker described at length over the past 2 months. In recent days, as the attacks on Mr. Mangi ramped up, the organization tweeted out, "It looks like our ad campaign worked." This ad campaign had nothing to do with truth. It was all about using secret billionaire money to derail a circuit court nominee who had not been blessed by this outfit and the billionaires behind it. Leonard Leo, as the billionaire's operative, has his fingerprints all over smears by another dark money group attacking Mangi. This one is run by a former Neil Gorsuch clerk who also oversaw the Kavanaugh nomination on the Republican side. Because this is a dark money group, we don't know all of its donors, but we do know at least two. And the first is, guess who? The Judicial Crisis Network. It's the glove in the hand in the glove in the glove. JCN, Judicial Crisis Network, helped get the second organization off the ground with more than $250,000 in 2018 and 2019. And when the new organization launched, its leader tweeted, "Excited to work hand in glove with a person named Carrie Severino, who is a Judicial Crisis Network lead operative, my other longtime friends at JCN, and many others on the outside who understand the critical importance of the judicial fight." And specifically, he means the critical importance to billionaires to be able to control the judiciary and get things done that Congress would never pass through courts that will do their bidding. The dark money ties don't stop just there with the Judicial Crisis Network front group and the front group for the Judicial Crisis Network. The front group organization's vice president comes straight out of the Koch brothers, K-O-C-H, not C-O-K-E, the Koch political dark money network. That guy helped run multiple Koch political organizations, including the dark money flagship of the Koch political machine, called Americans for Prosperity. While there, guess what? He helped oversee Americans for Prosperity's multi-million-dollar campaign to pressure senators to confirm Justices Gorsuch and Kavanaugh. Who's the other big donor? Donald Trump. Earlier this week, it was reported that Trump's PAC gave the organization $150,000 to keep up the dirty work. The leader of this group wrote an op-ed calling Mr. Mangi Hamas's favorite judicial nominee, and included a picture of Mangi with the Hamas flag edited to appear over his face, classy stuff again, and tweeted that Mangi should, and I'm quoting here, "Go serve as a judge in Gaza, you anti-Semite." Just beautiful stuff. Leonard Leo and Trump World are also propping up yet another dark money group attacking Mangi and other Biden nominees, the Conservative Partnership Institute. The New York Times recently called the Conservative Partnership Institute a, quote, breeding ground for the next generation of Trump loyalists. It has received millions of dollars from Donors Trust, which is widely known as, and I quote here, the dark money ATM of the right. It builds no product. It offers no service. What it does is launders the identity of donors so that if you're a big donor and you want to send money into politics, you send it to Donors Trust first, and then the report, say to the 501c4, says that the source is Donors Trust and not whoever really gave it. That's what it lives to do, and hundreds of millions of dollars flow through it. It also received $1 million from Trump's PAC in 2021. CPI is quite a cast of characters. Folks like Mark Meadows, Steve Miller, Cleta Mitchell, and Jeffrey Clark. One of its projects has been to find bad faith ways to sink qualified Biden nominees, and Mangi is just the latest of its targets. This same group was behind the false attacks on Ketanji Brown Jackson that smeared her as lenient on sex offenders. These groups are spending millions in dark money from Leonard Leo, from Donald Trump, and from billionaires like the Kochs to keep the federal courts stacked in their favor. They want to stop President Biden's nominees, who weren't handpicked by them in some Federalist Society back room by billionaires and their fixers. It's not just Mangi who's their target. They've tried to smear many other Biden nominees, and there is an unusual concentration in their targets of people of color. They seem to have a particular fixation with people of color. They ran the despicable ads accusing Ketanji Brown Jackson of being more concerned about the well-being of pedophiles than the safety of children. Judicial Crisis Network spent $1.5 million on ads attacking Justice Jackson during her confirmation. Again, that's the fake group with a fictitious name that purports to be, that actually is Concord Fund, but purports to be something different. Judicial Crisis Network also spent more than $1 million on a smear campaign against Vanita Gupta and $300,000 on a campaign attacking Dale Ho, both extremely qualified candidates of color. JCN's president has written numerous op-eds calling nominees of color like Judge Nancy Abadou on the 11th Circuit, the first black woman ever on the 11th Circuit, ideologues and extremists. And these groups have waged similar smear campaigns in other committees than Judiciary, with qualified nominees of color like Asale Omarova for Department of Treasury and Lisa Cook at the Federal Reserve getting the smear treatment. Adil Mangi is an eminently qualified nominee. He comes across with all the dignity and decorum of an Oxford Don. He's as well-trained and intelligent as any candidate who's ever come before the Judicial Committee, and he has been the subject of vicious, bad faith attacks. And the attacks come from this billionaire-funded right-wing apparatus. It is a scheme. It's not just a smear, it's an op. It's a covert operation designed to prevent the Biden administration from confirming well-qualified, fair-minded judges to our courts so that they can create a vacancy, so that if they can get Donald Trump elected in November, they can then put another right-wing extremist who will do what the billionaires want onto the court. With that, I yield the floor.
Rhode Island.
First, let me thank the chairman of our committee for attempting to bring this bill to the floor and to get us on it, even though the Republicans have objected to Supreme Court ethics. It's important for us to continue to make the effort because the American people understand that there's something gone very wrong at the Supreme Court. The objections that we just heard amounted to a long excursion through a great variety of topics, through abortion, through past FBI investigations, through allegations about a two-tiered system of justice, through wokeness, through things we all agree on, like separation of powers and an independent judiciary. I think it'd be helpful to actually come into focus on what we're actually talking about here, because most of what was said in opposition to this bill is completely irrelevant to what we are seeking to achieve. We all accept the doctrine of separation of powers. Senator Blumenthal, who is here, is an expert in the subject. He's argued more cases in the Supreme Court than any other senator. To be clear, our bill does not make the Supreme Court subservient to Congress in any respect. The bill obliges the judicial branch of government to create its own ethics enforcement mechanism that will be run within the judicial branch of government by the judicial branch of government. There simply is not a separation of powers concern when the judicial branch of government runs an ethics program for the judicial branch of government that is administered within the judicial branch of government. It just ain't so, Madam President. The existing state of affairs is that the ethics requirements that apply to the justices of the Supreme Court, first related to recusal, and second related to disclosure of gifts, are laws passed by Congress. And the enforcement, particularly of the disclosure requirements, is done by the Judicial Conference. The Judicial Conference is a body established by Congress. When Harlan Crow first started giving free yacht and jet travel secretly to Clarence Thomas, that question was taken up by the Judicial Conference a decade ago. Did the justices complain that the Judicial Conference was investigating Justice Thomas and his disclosures? No, of course not, because the argument would make no sense. So to hear it here on the Senate floor is a bit disappointing. Right now, the Judicial Conference investigates and can sanction or refer for further investigation justices of the Supreme Court. We are trying to fix three really simple problems. One is fact-finding. Fact-finding ought not to be an issue in dispute. Every member of government in the United States who is subject to any kind of supervision or ethics requirement, which is everybody, has a process whereby the actual facts are found of what went wrong. Hell, even the President of the United States had to sit for a fact-finding interview about the documents in his garage. It's only 9 people in the entirety of the United States government who think that they have no obligation to do any fact-finding. And that's pretty dangerous because we just saw Justice Alito offer facts, a description about what went on behind his family flying MAGA battle flags over their houses that has been proven false by information that is incontestable. Police reports with dates showed that he got the order of things wrong. COVID showed that it couldn't possibly have been a school bus stop. So you have erroneous facts offered by Supreme Court justices with no method to review them, or they completely ignore the facts. Justice Thomas has refused to ever say a word about what he knew about his wife's engagement in the insurrection while he was adjudicating the rights of those investigating the insurrection. There's nobody else in the world where somebody doesn't come in and say, "Sir, we have a complaint about your conduct and we're going to need to take a statement from you. This won't take long. I'm going to ask you some questions. You give your answers. At the end, we'll ask you to review and sign your statement." Nothing difficult about that. Nothing against the separation of powers about that. Nothing that Chief Justice Roberts couldn't require right now about that. He could have Supreme Court staff attorneys conduct exactly that kind of work right now, as the chairman has repeatedly pointed out. Fact-finding is a really basic elemental proposition of our American judicial process, and it applies everywhere. It makes no sense for the body ultimately responsible for policing proper judicial process in the United States to not allow itself to participate in that most elemental and fundamental task of there being actual fact-finding. The second is a principle so old it's in Latin, for Pete's sake. Nemo judex in sua causa. No one should judge their own case. That's pretty easy to understand. And yet we let these justices, alone in the United States, nobody else, get to be the judges of their own ethics. And obviously they have failed to measure up. And the third issue is transparency, disclosure. We know perfectly well that the justices have failed at their disclosure obligations, and they can't keep their stories straight about meeting their disclosure obligations. We just had Justice Thomas go back into his previous disclosures to correct them and tell the world and the Judicial Conference, which was reviewing this, that his failure to file was an accidental error. It was, quote, inadvertent. But earlier he'd said about the same gifts from the same billionaire, oh, those don't have to be reported. That was personal hospitality from a dear friend. Well, which is it? Is it personal hospitality that doesn't have to be reported? Or is it something that you knew perfectly well you should have reported, and now you're going back and cleaning up an error that you're claiming is inadvertent? The disclosure mistakes are inexcusable on their face. Federal officials who commit far less in the way of disclosure mistakes have actually been prosecuted as felons, as misdemeanants under the criminal law for those similar disclosure violations. So we need to get this right. All it requires is fact-finding and an independent voice, so it's not nemo judex. You're not judging your own cause. Those are really basic principles. That's all we're trying to do. It would be done by judges within the judiciary. There is no separation of powers issue. That is a complete canard. And I'll close by saying that the Judicial Conference has been helping us in all of this. The Judicial Conference has just blown up Justice Scalia's trick, which was to solicit through intermediaries free vacations from resort owners, and then when the resort owner invited him with a personal invitation, he would pretend that that was personal hospitality because it was a personal invitation, even if he'd never met the resort owner. That is a preposterous reading of the personal hospitality exemption. And it's not just me saying that. The judges of the Judicial Conference said, you are right. That is preposterous. That is ridiculous. We are clarifying the rule that that is not acceptable. And he had done it 60 times. He was a vacation-taking fiend, my Lord. So the idea that you can trust a Supreme Court justice with no independent review, no fact-finding, each the judge in his own cause, to follow the rules, has been blown to smithereens by the conduct of the Supreme Court justices themselves. As our chairman is fond of saying, this is a crisis in ethics at the Supreme Court that the Supreme Court itself has created. It is a crisis in ethics at the Supreme Court that Justice Roberts himself and the Judicial Conference can solve. But if they're not going to do it, we're going to do what we did before when we set up the Judicial Conference, when we set up the recusal laws, when we set up the disclosure laws. Set up the system and let the judiciary enforce it. I yield the floor.
Mr. President.
Back now for the 33rd time to keep shining a little light on the right-wing billionaires' covert scheme to capture and control our Supreme Court. As a result of that scheme, the court's right wing just took a wrecking ball to the government's ability to protect Americans from big polluters and corporate cheaters. This year's billionaire bonanza came through 4 decisions that gutted administrative agencies' ability to do their jobs. Perfect payback to the polluter billionaires who helped foot the bill to get these justices onto the court in the first place. The first decision is Ohio versus EPA, where the Supreme Court undermined the Environmental Protection Administration's ability to enforce the good neighbor provision of the Clean Air Act, the provision that defends the air quality of downwind states like mine, Rhode Island, from power plants and industrial facilities in upwind states, where sometimes they build the smokestacks extra high so that the pollution doesn't hit the polluting state, but it floats over and comes down and hits us in Rhode Island. Without even full briefing on the merits, industry litigants succeeded in getting the court to stall proposed clean air regulations and place a thumb on the scales in favor of polluters. At the hands of the Federalist Society justices, the right of polluters to pollute beat the right of Rhode Islanders to breathe clean air. Then came SEC versus Jarkissi, where the right-wing justices undercut the ability of federal agencies to hold fraudsters accountable through administrative enforcement proceedings. The court held that civil penalties for securities fraud required jury trial under the Seventh Amendment, undermining administrative adjudication in all sorts of civil enforcement proceedings across the federal government, protecting consumers from predatory financial institutions, workers from unsafe conditions, and the environment against polluters. I am angry that the court picked this case to express concern about the right to a civil jury, while it has been busily eroding that same civil jury right when doing so favored big corporations over regular people. If you're a fraudster on the losing end of a regulatory violation, they're all about the Seventh Amendment. If you're a consumer or employee injured by a big business, off you go to private, secret, mandatory arbitration. At the hands of the Federalist Society justices, the right of fraudsters to commit fraud defeated the right of people to be protected from fraud. In Loper Bright Enterprises v. Raimondo, the court overruled 40 years of precedent granting what is called Chevron deference to federal agencies when they're implementing laws that protect health, safety, and the environment. Chevron recognized that courts should defer to an executive agency's reasonable interpretation of a statute it's charged with administering. Just reading that sentence tells you how eminently reasonable the rule was. Plus, Congress can't be expected to make fine-grained determinations in technical areas that are best left to experts with decades of training and experience. In Loper, the right-wing justices removed that deference to expertise. The result? Look at this Washington Post headline. Corporate lobbyists eye new lawsuits after Supreme Court limits federal power. More ways for polluters to stall regulations with delays that can save polluters billions. Just to read this text, mere hours after the Supreme Court sharply curbed the power of federal agencies, conservatives and corporate lobbyists began plotting how to harness the favorable ruling in a redoubled quest to whittle down climate, finance, health, labor, and technology regulations in Washington. These cases are a power grab by a captured court, transferring regulatory authority from an elected Congress and an elected executive to an unaccountable judiciary ill-suited to make such technical determinations. Almost laughably, as they did this, Justice Gorsuch had to amend his opinion in that Ohio versus EPA case because he confused nitrous oxide, laughing gas, with nitrogen oxides that were the subject of that case. So much for judges knowing technical stuff better than the experts. The right of Federalist Society judges to make up fake science for billionaires triumphed over the right of regular people to have real experts defend them. Finally, in Corner Post v. Federal Reserve, the court held that the 6-year statute of limitations to challenge a federal agency's action begins when a person or entity challenging a rule is allegedly injured, maybe decades after the rule became law. Every regulation can now be litigated for eternity. Agencies will be perpetually vulnerable to litigation on every rulemaking, stalled by deep-pocketed litigants armed with exotic legal theories and the backing of this captured court. As Justice Jackson wrote in her dissent in Corner Post, the tsunami of lawsuits against agencies has the potential to devastate the functioning of the federal government. Even more to the present point, that result simply cannot be what Congress intended when it enacted legislation that stood up and funded federal agencies and vested them with authority to set the ground rules for the individuals and entities that participate in our economy and our society. At the hands of the Federalist Society justices, the power of special interests to tangle up regulatory agencies has defeated the right of taxpayers to protection from those special interests. Here's how I explained that protection in my amicus brief in the Loper case. Over the last century, our society has advanced remarkably. As industries and corporations grew, their motive to maximize profits caused social harms and threatened consumer safety. Regulation responded. Heavy equipment and dangerous chemicals came to mines, factories, and construction sites. Regulators implemented workplace safety standards. Meatpacking and mass production ballooned. Regulators implemented sanitation requirements in production facilities. Americans widely adopted automobiles. Regulators required seatbelts and airbags. The modern economy necessitated a modernization of the U.S. regulatory framework. Congress responded to the complexities of the modern world by ensuring that administrative agencies have the capacity, flexibility, and expertise to respond to new developments. Part of that project was delegating clear and broad authority to executive agencies and allowing those agencies to adopt and adapt regulations to respond to new hazards. As a result, daily life in the United States is safer. Workplace illnesses, injuries, and deaths have declined. Children on average have lower levels of lead in their blood. Foodborne illnesses that used to kill thousands of people per year have been practically wiped out. Highways are no longer carnage, and air travel is even safer than highway travel. So why tear down what has worked so well for generations? Well, the billionaire-funded think tanks say it's to strip power from so-called unaccountable bureaucrats. They love to talk about unaccountable bureaucrats. Except that federal agencies are not unaccountable. Indeed, they're way more accountable than judges. Again, from my Loper brief, agency experts report to politically appointed executive agency heads nominated by the President and confirmed by the Senate, accountable. These agency heads serve at the pleasure of the President, who is accountable to the people. If the public is unhappy with how agencies are implementing Congress's policies, voters can make that known at the ballot box. Congress oversees agency actions through legislative committees dedicated to agency oversight and regularly conducts oversight hearings where heads of agencies are called to account. Congress retains the power to enact legislation to limit or reverse agency rulemakings if it disagrees with the agency's actions, and in some cases on an expedited calendar. Furthermore, Congress holds the power of the purse. Every appropriations bill presents an opportunity to expand, correct, or contract agency authorities. If the public is unhappy with how Congress is holding agencies accountable, voters can make that known at the ballot box. Finally, agencies are accountable to the judiciary, which has the authority to review an agency's statutory interpretations and actions to ensure the agency's decisions are reasonable and follow appropriate processes and procedures. The myth of unaccountable administrative agencies is a fake. The real objection is that career agency employees are expert and can go toe-to-toe with industry trickery. And worse, for polluters, they can't put the fix in politically with a big campaign contribution or a couple of $1 million to a super PAC, because agencies are forbidden to take political considerations into account, and they are forbidden to self-deal. All of this wreckage of the long-standing protections of our administrative process was done by polluters who fund the Republican Party and paid to stack the court that dark money built. And this is the polluter's payday. A whole smelly ecosystem of secretly funded corporate front groups is involved. Anti-regulation doctrines get cooked up in right-wing hothouses funded by polluters. The doctrines get amplified by right-wing front groups funded by polluters. They then get fed to the court via little flotillas of right-wing amici funded by polluters. Secret dark money funding from billionaire special interests underpins the entire operation. Much of this is the Coke industry's political influence operation, a powerful right-wing dark money political polluter network. Look at that Loper case. The lawyers who represented the petitioners in that case worked for free, supposedly, for a public interest law firm, supposedly, called Cause of Action. Interesting law firm. It discloses no donors, and it does not report any employees. In fact, the New York Times discovered the group's lawyers, who supposedly worked for Cause of Action, actually work for Americans for Prosperity, the main battleship of the Koch political front group armada, an operation that is so cozy with the far-right justices it helped put on the Supreme Court that Justice Thomas has repeatedly flown out to join fundraisers for Koch political operations, including Americans for Prosperity. Here's the flotilla of front groups that appeared in Loper as amici curiae. The Buckeye Institute, the Cato Institute, the Competitive Enterprise Institute, Landmark Legal Foundation, Mountain States Legal Foundation, National Right to Work Legal Defense Foundation, New Civil Liberties Alliance, Pacific Legal Foundation, and of course, our dear friends, the United States Chamber of Commerce, a proper murderer's row of polluter mischief. And who are they funded by? Oh, let's look. Donors Trust, the Donors Capital Fund, the Koch family foundations, the Bradley Foundations, and ExxonMobil itself. Donors Trust and Donors Capital Fund are so-called donor-advised funds. They don't actually do anything. They don't actually produce anything, build anything. What they do is provide right-wing identity laundering services. Donors Trust has been described as the dark money ATM of the right, and with Donors Capital has laundered over $1/3 of $1 trillion into climate denial operations. If you're ExxonMobil or a billionaire polluter and you want to support climate denial, but you don't want your name on the phony front group that is doing the climate denial work, you send your check to Donors Trust. And they take it and they send the money where you tell them to the other group, only it's disclosed by them as coming from Donors Trust. It is an identity laundering operation for dark money political influence. Some amici also were funded by front groups affiliated with Leonard Leo, who we know as the billionaire's operative in this court capture operation. The Loper Amicus Advancing American Freedom received $1.5 million from Leonard Leo's Concord Fund between 2020 and 2021, $1.5 million. Leo's Concord Fund, which is this operation on this graphic, operates also under the fictitious name of the Judicial Crisis Network. When I say fictitious name, I mean under Virginia corporate law, Concord Fund has filed Judicial Crisis Network as a fictitious name, term of art in the law, under which it is allowed to operate without disclosing that it's actually the Concord Fund. Through the Judicial Crisis Network, Leo and his confederates spent millions of dollars on the court capture operation. TV ads, barrages of TV ads, huge checks in for $15 million and $17 million from undisclosed donors to pump the right-wing justices that they had chosen through confirmation. So this same group that helped push the justices from the Federalist Society lists onto the Supreme Court then files a brief through the Advancing American Freedom, $1.5 million from Concord into Advancing American Freedom. This whole thing is a billionaire-backed shell game in which the court willingly participates. And the connection between court capture and regulation destruction, that's not even in dispute. The court capture operation and the anti-regulatory operation were admitted by Trump's White House counsel Don McGahn to be, and I'm quoting him here, two sides of the same coin. You stack the court to tear down the regulations so your polluters are happy and they fund your effort to stack the court and support Republican power. And about this slate of recent decisions that I've just discussed, he proudly told the New York Times, and I'm quoting him again, "None of this was an accident. None of this was an accident. Indeed, it was bought and paid for." There is considerable literature about a phenomenon called regulatory capture, sometimes called agency capture. It's the capture of regulatory agencies by industry to corrupt government decision-making. You can imagine railroad barons taking over a railroad commission whose job it is to set the rates for their railroads. Well, the Supreme Court has been captured in the same way. And this was no small or incidental undertaking. True North Research estimates that at least $580 million has been spent on the court capture operation. These groups were a significant part of it, and these groups enjoy the benefit of it. Now, $580 million is a lot of money, but just these 4 decisions are payback for the polluters that makes that $580 million a cheap investment. And the public will pay the price, but that's a price that this captured court is happy to have the public pay. I'm going to conclude with Justice Kagan's dissent in the Loper case. She pointed out, because she saw this game play out right in front of her. She's over there on the court watching this game play out. And she pointed out that the polluters' justices stopped applying the Chevron doctrine back in 2016 as part of a plan, because, she said, they were, and I'm quoting her here, preparing to overrule Chevron since around that time. An 8-year-long plot to take out a precedent that bothers polluters. Forget calling balls and strikes. These justices were on a multi-year, billionaire polluters mission. And it's not just Chevron. This is a pattern. As Justice Kagan went on to say, this kind of self-help on the way to reversing precedent has become almost routine at this court. And here's how she describes it. Stop applying a decision where one should, throw some gratuitous criticisms into a couple of opinions, issue a few separate writings questioning the decision's premises, give the whole process a few years, and voila, you have a justification for overruling the decision, something she called an overruling through enfeeblement technique that mocks stare decisis. As she described it, this captured court, at the big donor's direction, stalks for years and then kills off precedent that the billionaires don't like, precedent that interferes with their polluting or interferes with their cheating. That stalking and killing plan may be a lot of things, Mr. President, but I'll tell you what it's not. What it's not is judging. To be continued, Mr. President. I yield the floor.
Thank him once again for his courtesy.
Senator from Rhode Island.
Thank you, Leader Schumer. The right-wing FedSoc justices also took away women's right to an abortion, leaving millions of women unable to make basic decisions about their own reproductive health and endangering women experiencing troubled pregnancies. They overturned long-standing and overwhelmingly popular gun safety laws, leaving our communities exposed to the epidemic of gun violence. They eviscerated the government's ability to fight climate change and to protect consumers from corporate profiteering. And they invented, out of thin air, the idea that former presidents are absolutely immune from being held accountable for using their office to break the law, to commit crimes, even to commit treason. On top of all this, the court has done its best to prevent the American people from fighting back through the democratic process. It's made it harder for ordinary people to vote, while making it easier for billionaires and deep-pocketed special interests to impose their will on the American people with unlimited amounts of dark money. How did we get here? A decades-long scheme led by creepy billionaires and backed by a deluge of dark money captured the court like some crooked 19th century railroad commission. This court capture operation was not cheap. The latest estimate put it at more than $580 million, and that's a minimum. That money flowed in from creepy billionaires, laundered through right-wing front groups like the Federalist Society and Judicial Crisis Network, where the donors, the real donors, could hide their identities behind the front groups doing their dirty work. This dark money funded full-scale campaigns to stack the Supreme Court with justices who would deliver for the billionaires. This scheme's major victory came when Senate Republicans blocked Merrick Garland's confirmation to the Supreme Court. That set the stage for Donald Trump to fill that seat through a process outsourced almost entirely to the billionaire's operative Leonard Leo and his array of right-wing dark money front groups. Once these hand-picked nominees landed on the court, the dark money network tells them how to rule, supplying them with extremist legal arguments through so-called friend of the court briefs designed to reach their desired results. And the parallel between what the friend of the court brief flotillas recommend and what the FedSoc justices do is nearly perfect. Leo and his cronies also orchestrated a secret gifts program for their amenable justices, keeping them happy with lavish gifts of luxury vacations and other high-value freebies. Despite a clear federal ethics law requiring Supreme Court justices to disclose even small gifts, these justices kept hidden years of free private jet travel, free yacht trips, free tickets to sporting events, even for one justice, $260,000 of loan forgiveness for a luxury motor coach. Justices have flouted the federal law requiring recusal from cases where they have a conflict of interest. Justice Thomas sat on cases involving efforts to overturn the 2020 election, despite his wife's involvement in efforts to overturn the 2020 election. Worst of all, the court has refused to take any real steps to clean up this mess. After substantial public pressure, it first wrote a useless letter about ethics, and then it adopted a toothless ethics code with no mechanism for either investigation or determination or enforcement. The Supreme Court now stands alone in all of government, free from any fact-finding about ethical misconduct. As a result, the court's legitimacy in the eyes of the American people is now at an all-time low and falling. Well, against all that mess, earlier this week, something big happened. On Monday, President Biden and Vice President Harris endorsed two common-sense proposals to help restore the court's legitimacy. And happily, I have bills that perfectly align with both. First, the Supreme Court needs a binding enforceable code of conduct. The Supreme Court should not violate one of the most basic principles of the law, nemo judex in sua causa. No one should be a judge in their own cause. Yes, that is a principle so old and so venerated that it is in Latin, and they violate it non-stop. The justices of the Supreme Court should have ethics rules at least as strict as the other branches of government, with a real process for finding out what happened and holding miscreants accountable. And overwhelmingly, Americans agree. Last week, Justice Kagan suggested that a panel of experienced lower court judges could review ethics complaints, compile a report, and then make recommendations to the Supreme Court. That's exactly what my Supreme Court Ethics Recusal and Transparency Act would do. And by the way, it's also what most all state Supreme Courts do. They all face the same problem of being the top Supreme Court in their sovereign entity, and they all face ethics review by other judges or panels. This is a solvable problem. My bill would also impose stricter disclosure of gifts justices receive, enhance existing recusal laws, and require the flotillas of phony front groups who lobby the court through friend-of-the-court briefs to disclose their actual funders and connections. My bill passed the Senate Judiciary Committee last summer with the warm and welcome support of the presiding officer, and it's now awaiting a vote on the Senate floor. Democrats stand ready and willing to deliver on President Biden's and Vice President Harris's goal of bringing real transparency and accountability to the Supreme Court. President Biden and Vice President Harris also announced their support for 18-year term limits for Supreme Court justices, with new appointments to the court occurring every 2 years. That would counter the Republican Supreme Court justices' penchant for strategically timed retirements that tip the court into Republican hands. Term limits are a common-sense proposal with long bipartisan support. Supreme Court justices, including Chief Justice Roberts, have expressed support for term limits. Even some of our Republican colleagues have endorsed the idea. And a Fox News poll earlier this month showed that this idea has support from more than 75% of Americans. Fortunately, Democrats stand ready to deliver on this idea too. My Supreme Court Biennial Appointments and Term Limits Act, which the distinguished presiding officer is a co-sponsor of, would make the court more representative of the American people and lower the political stakes of Supreme Court nominations. Under our bill, the president would appoint a new justice every 2 years. Justices would serve full-time on the court for 18 years, after which they would acquire a form of senior status, something familiar to anybody who knows federal courts, where in district courts and circuit courts of appeal, judges go on senior status regularly. And these justices on senior status would remain on the court to hear the original jurisdiction cases that are required by the Constitution for the Supreme Court to entertain. The 9 most recently appointed justices would hear what the Constitution calls appellate jurisdiction cases, which the Constitution expressly gives Congress the power to regulate. So Congress can pass this long overdue reform while preserving judicial independence and without a constitutional amendment. President Biden noted that he has overseen more Supreme Court nominations as Senator, Vice President, and President than anyone living today. Vice President Harris, a former member of the Senate Judiciary Committee herself, has echoed the President's calls for reform. Both the President and the Vice President have immense respect for our Supreme Court and for a strong and independent judiciary. They've demonstrated it through their lifetimes. And that is exactly why we should listen to them when they tell us that the time has come for reform at the Supreme Court. This has been a long and often lonely fight in the Senate. The big money right-wing apparatus has tried over and over to shut me up. I think I may have a record for hostile Wall Street Journal editorials. And may I tell the Wall Street Journal editorial board, thank you, that is a badge of honor. Realization of what is needed to save the court from itself has spread, first through the halls of Congress, then into the national consciousness, and now to 1600 Pennsylvania Avenue. That is good reason for hope. So bravo, Mr. President and Madam Vice President. Now it's up to us in Congress to deliver and repair and redeem this captured court. To be continued. I yield the floor.